This week on Words and Numbers, college grades, again.
The TSA and privacy.
Transgenderism and the WNBA.
And Clark Neily joins us to talk about how to read the Constitution.
All this and more coming up on Words and Numbers.
Hi, I'm James.
And I'm Anthony.
And this is Words and Numbers.
So, Ant, let's do it exciting in your world this week.
This interesting thing in the news, which I'm sure you've seen, Atlanta resident Samuel Tunick is facing felony charges for using what's called a duress passcode on his phone. He comes into the country.
Yep.
Yeah, he comes into the country, and TSA, as TSA apparently is allowed to do, which baffles me nonetheless, takes his phone. Now, the guy's on U.S. soil, takes the guy's phone and demands that he unlock it so that they can look at it or whatever. And, I mean, right away, you got this question of the constitutional right to privacy, Fourth Amendment, all that stuff. Put that aside for the moment. Tunick is running on his phone what's called Graphene OS, a particular operating system. And Graphene OS has a duress passcode. So in just such situation, you're being forced to enter a passcode. You don't enter in your regular passcode. You enter in the duress passcode. The duress passcode ostensibly wipes the phone. And so the argument here is, the argument the federal government's making is that he destroyed evidence. Again, putting aside the question of that there was no crime here for which to be destroying evidence, but nonetheless destroying evidence. All kinds of interesting things come up here. For one, Tunick himself did not enter the passcode. It was the TSA agent who's holding his phone demanding the code. Tunick recites to him the duress passcode. The TSA agent enters it, thereby ostensibly wiping the phone. And you get the argument for destruction of property, except that the TSA agent did it, not him. But nonetheless, there's a more interesting twist. And the interesting twist is the duress passcode doesn't delete the files on the phone. It only deletes the encryption key. So it's not analogous to shredding documents. It's analogous to putting the documents in a safe, locking the safe, and throwing away the key. There is no destruction of evidence here. The evidence is all there. In fact, the TSA could, if it had a ton of computing power and a lot of time, break the encryption and see the data. Of course, they're not going to do that. So all kinds of questions, beginning with the Fourth Amendment and the right to privacy, but going all the way down to this question of, actually, he didn't destroy evidence at all.
Yeah, and, we used to think about this sort of thing only when we would travel to foreign countries with authoritarian regimes.
Yeah.
Right? If you're going to travel to China, you should probably leave your regular phone at home, get a new phone, bring that one with you, have minimal information on it, because they're going to go through it. And if you don't want people seeing what you're up to, and, who of us really does? I don't want anybody butting into my personal life.
But it's more, I'm with you, but it's even more than that. If someone got hold of my phone and opened it up, they'd have access to my bank accounts, for example.
That's right. They'd have access to your entire life. Yeah. Our entire lives run through these very small rectangles that we carry in our pockets now. And it's no shock to me that government wants to get its greedy little fingers into it. I think we should all be figuring out a way to say no whenever this comes up.
And you would think that the Constitution has already said no. I mean, this guy's on U.S. soil. He's a U.S. citizen. How is it that the TSA, absent any evidence of a crime, is able to demand that he unlock his phone?
Yeah, well, maybe we're just redefining now what a border is. Because remember that those first batch of miles inside the border, you don't have Bill of Rights protection, which, by the way, covers like 2/3 of the population of the United States.
Yes.
Maybe they're just bringing that little bit of reason to places like airports.
But that's worth that's worth repeating. And this came about back in the years of COVID, when they changed the rules, basically eliminating your Fourth Amendment protections at the border. At the same point, they defined the border to be anything within 100 miles of a U.S. border, which means basically the entire coastline, the entire north, the 100 miles to south of Canada, 100 miles north of Mexico. So you're well within the border. Even when I used to live in Pittsburgh, was just over the border.
Yeah, no, I am. If the border goes from an imaginary line, which is what it is, to 100 miles past that imaginary line, the majority of the American public does not have First Amendment, does not have Bill of Rights protections.
Right.
Isn't that great? And now apparently a TSA agent, because he feels like it, can say, give me your phone, which means you can also give me your computer or your tablet, and then force you to open it so he can go through it and find out whatever he thinks he wants to find out.
Mm-hmm.
This is not great. Let's just leave it at that. Right? Not great. This is one of those weekends where it was such a target-rich environment. I didn't know what to pick. But the University of Michigan has now, and look, it's no short list, but the University of Michigan has lost its mind, along with all kinds of other institutions of higher learning, because incoming students will no longer get real grades. What does that mean, you say? Just pass or no credit?
Oh, wow. So everything is pass. It's not even pass-fail. It's pass
or no
pass.
Credit. Because the precious snowflakes can't bear to get anything other than the A's they've always gotten. So now we're going to fix it. So there's only two outcomes for you: pass or no credit. We're not even calling it failure.
Right. So no credit is basically as if you'd never taken the course at all.
That's right. You'll just have to take it again with, no effect on your academic bottom line.
Mm-hmm.
I saw a kid the other day. I wish I had called up the link. I didn't even think about it. But he graduated high school with a 12-point-something GPA. And if you ever needed evidence that a grade point average has been completely divorced from reality, there you go. Because a GPA is a number between 0 and 4.
And let me remind our listeners who are in high school or even college what you and I have said repeatedly as college professors. If I see a 12.0 coming across my desk, I'm ignoring that student entirely. Because I'm assuming that whatever it is that led to that outrageous GPA was did not constitute difficult courses of study.
Not only that, but he's a master of gaming systems. And
right.
I don't want to be gamed that way by somebody who's probably going to be working for me. So no, thank you. Do I admire the chutzpah, the cleverness, however you want to put it? I kind of do. But it's proof that the system is broken, not that there's something wrong with this young man.
Right.
Right? It's just broken. If you can take a 4 scale and somehow get a 12 out of it, the system is broken.
And again, going back to the GPA, I have always thought that the optimal GPA is around 3.738. Because when I see a 3.738 student, I see someone who has worked hard to get a high GPA and isn't afraid to take difficult courses. So we've got a few B's, maybe a C here and there. I see a 4.0, and I think this person managed to get through the entire curriculum avoiding difficulty.
Yeah, people are going to find this hard to believe in the era of great inflation because everybody now has a 3.9 or a 4. Right, but I graduated with a 3.58, something like this.
Yeah, and that was substantial back in the day.
And I was in the top 2% of the class.
Yeah.
That was a big deal. I made Phi Beta Kappa at 3.58. 3.58 now is a laughable grade point average.
Right.
I mean, it's not bad. It's laughable. So here we are. And it's just another chink in the armor for higher education. We're going to end up with another situation in which people are going to look at college grads and say, I don't know the difference between you and a high school graduate.
Mhm.
I have to pay you more, so I'm not going to. And I won't blame them at all. Anyway, that was not the foolishness of the week. The foolishness of the week is even better. And I think, Aunt, this might only be the second time, but I love saying it out loud. The foolishness of the week comes to us courtesy of the WNBA. Do you even know what those letters stand for?
Women's National Basketball Association?
Hey, look at you. You have learned.
I only know it because of what's her name, Sophie, that's all over everything.
Yeah, Sophie Cunningham, if you're out there, I am quite smitten by you. And if you would like to come on.
Now you just
and
scared
talk to
her
me-
away, for God's sake.
No, she can't be scared away by the likes of me or anybody else. That's why I like her so much.
Sophie,
She
come
is so-
on, Words and Numbers. We'll both berate James at the same time.
That might be okay. I'm just going to leave it at that. Anyway, moving right along. This actually does involve her in an oblique sort of way. The NBA, for the WNBA, and I don't want to be really kind of upfront, honest, inclusive here. The NBA, the WNBA does not have a trans problem. Right? There aren't trans women playing in the WNBA. It doesn't really seem to be an issue. And yet Sophie Cunningham did kind of light the world on fire when she made some trans remarks about the WNBA and women's sports more broadly. And I think that it's a point well taken, right? You should women's sports were designed to be gender exclusive of men because men and women cannot compete fairly. Men win every time. It's just how it is. And, in a sprint, a man kills a woman. In a marathon, a man beats a woman, but not by as much. And, there are things you can say. The best women's tennis player in the world couldn't hang with somebody in the top 100 from the men's side. Probably the top 200 or even 300. They can't even return the serve. It comes in so fast, right? A man fighting a woman, that woman might die, right? And these are the kinds of things that concern people who aren't first concerned with gender ideology, right? There are reasonable things to be concerned with here. And Sophie Cunningham, I don't know where she falls on this spectrum, but she said some things about trans athletes and the WNBA, but that's her employer. That's how she makes her living. I don't blame her for that. But then, Aunt, a league that didn't have a trans problem immediately got itself a trans problem. It's almost like the Streisand effect, right? Where Barbara Streisand gets all pissed off because somebody takes a picture of her house. I just reread about this the other week. Somebody took a picture of her coastal home and posted it online. And she brought suit because her privacy was violated. But by the time she brought suit, only 6 people had downloaded the photo, and 2 of them were her attorneys. The day that she had the day that she announced the lawsuit, millions and millions of people downloaded the photo. So this is kind of like that in a way, because no sooner did my gal Sophie start saying what she was saying, that a former NBA player declared himself eligible for the 2027 WNBA draft. Enes Kanter, 6'10". He's a big fella.
Wow.
And he averaged 11 points and 7 rebounds in the NBA on over 50% shooting from the field, which is pretty good for the NBA. If he walked into the WNBA, even at his advanced age now, he'd probably score 80 points a night. Every game he played, they would win. This is just literally true. And the problem the WNBA has is that they haven't had a very clear point of demarcation about who's eligible to play. Because, and you can see why, who wants to step on that landmine?
Right.
Right? I mean, you'd have to be an idiot. But then it got a little worse because a second ex-NBA player has now declared himself eligible for the draft. And this one's even funnier because it's a guy named Royce White. And a number of our listeners from the Midwest are going to know exactly who Royce White is. He likes running for office in Minnesota. Amy Klobuchar beat him by 15 percentage points in a Senate run. He's now again in a primary race to get back. Pretty clearly going to lose yet again because, Republicans in Minnesota don't exactly do well. It's hard to imagine that Royce White is going to be the one to finally crack through that market. But now he's declared himself eligible for the draft too. And I think, the WNBA has a very easy response to this. Just don't draft them.
Mm-hmm.
It's just that simple, right? Don't draft them. And I don't imagine any team would. Because they're clearly making another point. They're just like Sophie Cunningham, right? They're making a political point in the midst of a non-problem. But there will be a problem sooner or later, and as problems go, it's very likely to be sooner. And what are they going to do then? And for that, I don't know. And I'm a fan of women's sports, which means I'm generally a fan of women. Right, I think they should have their own things, and I like watching them when they do their own things. And I don't want them to get hurt by men, because men are just built differently. And, that doesn't make me transphobic. As a matter of fact, Aunt, I'm a little irritated with the addition of phobe onto any word and then applying it to vast swaths of the public. I'm not afraid of anything. I'm not a transphobe. I'm not afraid of trans people. I've never been a homophobe. I mean, who the hell is afraid of gay people? What the hell's wrong with you? I mean, I might be afraid of bees, and I did find a rattlesnake in my pool last night, and I'm a little afraid of that. I was just about to jump in, as a matter of fact, when I saw this little bastard swimming around. Now, that's a healthy time to have a fear. Fear teaches you something. There's a snake in my pool. It could bite me. It'll hurt. I'll have to go to the hospital. That anti-venom is expensive. Men in women's sports? No, I'm not transphobic. I just don't think it's fair. And that's reasonable. And reasonable people can disagree on this. This is not unlike the abortion debate in a lot of ways, because it's a question about fairness either way. How are we to be fair to women as a large group? How are we to be fair to trans women, which will always, by definition, be a small group? And I would like to be fair to all of them. But sometimes the rights are going to come into conflict. And then we have to make hard decisions. And for me, this decision isn't hard. Men shouldn't be playing in the women's game.
Clark Neily joins us this week. Clark is our good friend and Senior Vice President for Legal Studies at the Cato Institute and author of Terms of Engagement, How Our Courts Should Enforce the Constitution's Promise of Limited Government. Clark, thanks again for coming to join us.
Always a
I'll even
pleasure.
go so far, Clark, and I rarely say this kind of thing in public about any human, but Clark is a good human being.
He is. I very much enjoy hanging out with him, which is more than I can say for a lot of people.
Yeah.
Clark, here's what I asked for us to do this episode as kind of a follow-up to a conversation James and I had had on one of the episodes about originalism versus textualism, and I'm going to throw out definitions being the non-expert here. Originalism is reading the Constitution and trying to get to the original meaning of the word. So, for example, in the Second Amendment, militia is mentioned. What does militia mean? What did it mean to the founders when they used that word? Textualism is just reading the plain words on the page, what it says in terms of what the words mean today. And if I remember you correctly, James, you fall into the textualist camp.
I think that's fair. I'm a textualist, but I have deep, deep, deep sympathies for originalism.
And in the textualist conversation came up from our talking about
it was birthright citizenship.
Birthright citizenship. And do you recall the word that we were messing with? Oh,
Clark does.
Clark
Yeah.
does.
It was jurisdiction.
Jurisdiction. Okay. All right. So as I understand the argument, and I'll let you two weigh in here, but as I understand what James was saying to me is, look, the word jurisdiction has meaning today. It may have meant something earlier on, but it has a meaning today. This is what the meaning is. Therefore, when we read the Constitution, we should apply the meaning of the word as it exists today. And that really made me uncomfortable because it seemed to me like we can, in effect, amend the Constitution just by changing the definitions of words.
How would you like me to set this up for you in a way that your listeners will love and will immediately make clear to them what's going on?
Please do.
All right.
Make it as easy as you can, because I'm not even, as Ant recounts my former position, I'm not even clear that that's my position.
Yeah, no, I appreciate that. I think we're going to have, this is going to be, I think, maybe my favorite appearance, and we haven't even really gotten into it yet, because what we're about to talk about is so important, so challenging in so many ways, but actually, there's a tremendous amount that we can really, I think, clarify pretty easily in ways that I think people are going to find to be convincing and useful. So let's start with this. There are some cases where originalism and textualism might actually point in different directions, and that's useful to know. And I'll give you an example. There are two places in the text of the Constitution that says that Congress shall have the power to lay and collect taxes. That appears in Article 1, Section 8, which is one of the delegated powers to Congress, and also in the woefully misguided 16th Amendment, which empowered Congress to collect taxes on incomes which it did not have until that amendment. Now, look at it very carefully. Congress shall have the power to lay and collect taxes. Well, who actually collects taxes in our system of government?
It's
Is it
the
Congress?
IRS under
Executive
the executive
branch.
branch.
Exactly right. So textualism would point us in one direction, namely that if it's not Josh Hawley or Ted Cruz at your door with a handout collecting taxes, but instead the commissioner of the IRS, then the Constitution is being violated. You don't have to hand over your tax money. Originalism, I think, would point in another direction or a different direction, and it would say, all right, in the history of either America or Great Britain, have legislators ever actually had to go out and collect taxes? And the answer is no. And would that language have been understood at the time to mandate that actual legislators go out and collect the taxes? And the answer is no, it would not. So we can see that textualism and originalism can go in different directions. And I think in this case, there's a clearly correct answer to the question of whether textualism should prevail or originalism, even though you could come up with some non-trivial, ridiculous reasons why it might be good to have actual legislators collecting the taxes. You could, among other things, you could have a conversation with them about why your taxes are so high as they are collecting them. But that's just not the way that any, I think, certainly no judge and very few people familiar with the relevant history would interpret that provision to require members of Congress to actually go out and do the collecting, even though that's what the words literally say. I'll give you another example. And this one really helps us distinguish between originalists and non-originalists. Imagine, and this is not something, as far as I know, that is in the New York State Constitution, although I will admit that I didn't check. Imagine there were something in the New York State Constitution that was enacted sometime in the late 1700s or the early 1800s that said that everyone who owns land along Long Island Sound has the right to collect an unlimited number of fish every year. At that time, the word fish would absolutely have included whales. In fact, that's almost certainly what they would have been talking about. Because you wouldn't go out of your way to say, hey, you can catch as many flounder or herring or whatever as you want. You'd be talking about whales because that was the most commercially valuable thing in the ocean at the time. An originalist would say that that constitutional provision still protects the right of riparian owners, that means owners of water-adjacent land in New York, along Long Island Sound, to collect as many whales as they want. Why? Because that was the original public understanding of that word, fish, at the time it was enacted, and that meaning remains fixed until the Constitution has been properly changed. Even though we now know that whales are not fish, they are mammals. So we have a different understanding of the word than they did, but original public understanding version of originalism, and man, there are like 31 different flavors here, but I'm talking about original public understanding, would say that that constitutional provision enacted in the late 1700s or early 1800s to this day protects the ability of people to take whales in Long Island Sound until it is changed.
But you just said a really interesting and I think the most important thing that could emerge from this conversation. Until Congress changes X, or until we update the Constitution. And,
Right.
and,
That's
and,
right.
and these are things that the founders assumed would happen, right? That if we needed to change the Constitution, here's the amendment process. It's a high bar, but you can do it. And the 16th Amendment, the idiotic income tax, look, we did that. We foisted prohibition on ourselves, and then we got rid of it. So you can't tell me a constitutional amendment is impossible. So the words on the page have to matter.
Yes,
and there
they
was
do,
nobody.
but this is not a license for judges to throw up their hands when there's a close question. So just let me give you an example. We have no idea what the founding generation would have said about whether flying a drone up to somebody's bedroom window to look inside was an unreasonable search.
Right.
We can surmise, we can look backwards and guess, but we can't know because they wouldn't have had any concept of a drone back then. So that would be like conducting a seance, and we're not doing that. But that doesn't entail that, therefore, until we amend the Fourth Amendment to specifically call out drones looking into bedroom windows as an unreasonable search, that A, government gets to do it, or B, that judges get to just throw up their hands and say, well, it says no unreasonable searches, and I don't know whether a drone looking into windows is reasonable or unreasonable, so I'll wait until somebody amends the Constitution.
Yeah, but see, that was an interesting sleight of hand that you just pulled there. It was probably inadvertent. But you started by saying, suppose somebody ran a drone up to your bedroom window, and then ... government, the police, right? But you started with somebody, not the government.
No, James, that doesn't help. You obviously know I meant police. That's not just somebody.
Yeah,
The Fourth Amendment does not apply to private citizens. You know that I know that, and I know you know that. So it's the police looking in your window.
I think that's right. I'm not being nasty about it. I'm
All
just,
right. I know.
Just making
But I'm
the
saying
point.
it's an interesting move because it's an effort to sort of address the easy cases right off the bat. We're not talking about private people. We're talking about the police looking in your window with a drone. And let's be clear. Not only does the text of the Fourth Amendment not address that situation sufficiently clearly to know what the answer is, it's also impossible to project backwards and suppose that we can know what the founding generation would have thought about that situation because they couldn't ever have conceived of it.
I think there's a more interesting and more difficult example, actually, and it's one that I ended up having a number of very heated disagreements as I trained in my PhD program on constitutional law. And William Howard Taft was involved, and I can't remember the case name to save my life, but it was a wiretap case. And the question before the court was, is this somehow an invasion of privacy? And of course it is. You're shaking your head because you know how that case went.
No, I'm shaking my head because that's not the question before the court. There is no general right of privacy in the Constitution. The question was whether it constituted an unreasonable search.
But there it is. When you look at the Fourth Amendment and the list that is provided there by the framers of that amendment, what you see is the entire universe of privacy at that moment is in that list. So as new technologies emerge, I would make the claim they end up in that list because that list was the entire universe of property. And you see here, I'm violating my textualist leanings, right? But there's another more interesting thing, and this is the one that I think should get everybody's attention. The First Amendment protects, among other things, the right of the press, right of a free press. Does the internet count?
Right.
Broadsides and pamphlets would have been covered under that.
Let's quickly go back to your point about wiretapping, because I think that's going to give us an opportunity to do something really important, which is to articulate a workable theory of how to interpret the Constitution when it's applied to facts that the founders could never have imagined. So the case you're referring to is called Olmsted versus the United States, a 1928
Olmsted, thank
case.
you.
Yeah.
Thank you.
Yeah. And, I think that decision, which basically said that wiretapping is not an unreasonable Fourth Amendment search, was an example of the kind of case where judges essentially say, well, there were no wiretaps back then, so who knows? It's not really my business. It's okay. I think that is not that's not the optimal way to approach these cases. And I would contrast a more recent case called Riley, and I'll get the year for that in a second. But Riley involved the question of whether the rule that the Supreme Court had announced that police may search your wallet when they arrest you should be applied to your smartphone. And the government said, hey, smartphone's just basically a wallet that has more stuff in it. And of course, the defendant said, no, a smartphone is not anything like a wallet. It has your whole life in it. And unanimously, the Supreme Court agreed with the defendant and said, this is not a wallet. It's not a backpack. It's not a suitcase. This is more like the key to everything in your life. The whole, your entire study back in the old days that, Aunt and James and I would have actually kept paper files on things, but to update it, this is like giving them access to your whole Dropbox account or your Google Drive or whatever. And that would include everything from, pictures from your family vacation to sensitive medical information, tax history, etc. And to its credit, the court kind of updated its heuristic, updated its conception of what the Fourth Amendment's protection against unreasonable searches must apply to, even though the founding generation could never have conceived of anything like a smartphone. And I think they clearly got the case right. I don't think it was an accident that it was unanimous.
Now, I want to just take a side quest here for a moment, because in our opening comments, I raised this issue about Tunick, the guy who came into the U.S. and the TSA demanded his smartphone, and he gave a duress password. The thing was deleted. But how does the TSA's ability to demand the smartphone access square with what you just said?
So there are two things that basically destroy any possibility of rational discussion in a philosophical or constitutional discussion or analysis, and that is introducing kids and borders. Basically, the Fourth Amendment goes out the window at the border, and the Supreme Court has made little, if any, effort to develop any sort of coherent doctrine about what government agents can do to you at the border or not do. I would say up to and including, can they just do suspicionless cavity searches of everybody who gets off an international flight? I think the Supreme Court's reaction to that case, if it ever came up, would be something like this: shrug. So that's why they were able to demand access to that smartphone, is not because that's something government agents generally get to do. It's because it was at the border and he was trying to get back in the country. And the border is special, according to the Supreme Court.
So let me just ask you a fine point here. He was, to my understanding, he was in the United States at that point, but I'm presuming he was in an airport.
He has not yet been admitted back into the United States. So whether we call it a border or just a checkpoint, the point is that encounter occurred under circumstances when he was trying to gain re-entry back into the United States. And yes, it was in an airport. But as anybody who's ever been questioned extensively by whatever ideation of Customs and Border Patrol existed at the time, as I have, I went to Thailand one time on vacation and had to cut it short because I had an appellate argument that got moved to the middle of my vacation, because of course it did. And so I had to change my ticket, in the middle of my vacation. And for whatever reason, this must have thrown about 100 switches with the customs folks, because I have never had a longer discussion with a customs agent to get back into the country, right up to and including questioning me what on earth I was doing with a mask, fin, and snorkel. And I'm like, snorkeling. I was snorkeling with my snorkeling equipment in the water. They did finally let me back in. I got to argue the case, and I won it 3-0.
Took me an hour and a half to get into Montreal, where I had to stay for 6 weeks after living in Iraq for a while.
Yeah.
An hour and a half of a woman just consistently saying, I don't understand why you're coming to Canada. At the end, I said, at this point, neither do I. And she said, okay, you can come.
That was the magic.
Those were the magic words that unlocked the Canadian case.
That was the cheat code. So I don't want to be glib about this, but I will say that oftentimes when we talk about children and or borders specifically, we may not actually be having a very interesting conversation, because it's usually not generalizable, if that makes sense.
Yep.
It's interesting, Clark, because on the one hand, we're talking about deeply important things, right? The minds of the founders as they constructed the Constitution, the minds of the men who framed the amendments that define our lives and all of this. And on the other hand, we could be talking about phenomenally stupid things. And this is very typically Congress, right? Congress writes a law. They don't do it well. And if you think, if the listeners think that Congress writes sensible law, I defy you to just go read one.
I wish I had this at my fingertips, but there is actually a piece of legislation that was passed, I want to say in the 60s and 70s, that includes the phone number of a woman that one of the staffers who drafted the legislation was hoping to go out on a date with. It's in the actual law that got passed. So, so that happens.
On.
But let me try one more thing. I think this should be an interesting way to explore this question of whether originalism is a useful concept. And it relates to a case that the Supreme Court is actually going to hear in the upcoming term. I'm sure all your listeners will remember, but if they don't, I know you will, that there is only one right that is mentioned both in the unamended text of the Constitution and the Bill of Rights. The only right mentioned twice in the Constitution. Do you happen to remember what it is? It's the right to a criminal jury trial.
Yeah, jury trial.
It's in Article 3, Section 2 and the Sixth Amendment. Now, here's a question. There are only two actually enumerated, meaning spelled out in the text, attributes of a criminal jury that are listed in the text of the Constitution. In Sixth Amendment, it says that a criminal jury has to be impartial, and it has to be drawn from people living in the state and district where the crime has occurred. Now, are those the only constitutionally required attributes of a Sixth Amendment compliant criminal jury? Answer, no. That's pretty interesting. So, for example, could you have a jury of two people? Nope. Why not? And where does that come from? Well, it comes from hundreds of years of common law practice. It comes from a historical context in which we understood that a criminal jury, in the understanding of everybody who lived at the time of the founding, would have understood that there is no such thing as a two-member criminal jury. No such thing exists, or a civil jury for that matter. A harder question is, okay, well, what is the number? And for about 50 years, the U.S. Supreme Court has said, clearly erroneously, 6 is the minimum number. They pulled that out of somewhere. I'm not going to say where. It wasn't the air. It might have been a body part. But 6 doesn't come from anywhere coherent. They just said it. In part, I think, because Florida had adopted 6-member felony juries in all non-capital cases. I will tell you that was overtly for racist reasons, because the more people you put on a jury, the greater the likelihood of either an acquittal or a hung jury. Because why? Because jury verdicts have to be unanimous. Interestingly, that's another thing that's not spelled out in the text of the Constitution, but is accepted without reflection or objection by nearly all Americans, is that in order to be legitimate, a jury verdict must be unanimous, or at least a verdict in a criminal case must be unanimous. Where the hell does that come from? Not the text of the Constitution. Where? Originalism, original understanding of how jury verdicts are produced, that they have to be unanimous in criminal cases. Here's another attribute, I would say, of a Sixth Amendment compliant jury: the opportunity to deliberate, to discuss, to interact with one another before you come up with a verdict. If at the end of closing arguments, you sent the jury out into 12 different cubicles and isolated them and just said, look, reflect on what you've heard and hand out a slip of paper that says guilty or not guilty, and all 12 people from their cubicles said guilty, I do not believe that would be a valid verdict. Because why? Because they did not have the opportunity to deliberate. But that's not spelled out in the text of the Constitution either. You have to resort to some interpretive theory to get there. And what is that theory? It's some version of originalism.
Right.
All right, so
And
let me push back a little bit on that.
Yeah.
So what I heard you say was, yes, juries are 12 people, and yes, juries have to come to unanimous agreement because that's what the word jury has always meant. It's what it meant to the founders when they wrote the thing. And yet we have the Second Amendment argument that when they talk about arms, all of a sudden it includes things that they didn't mean.
So that's a really important point, Ant. There's a big difference in originalist circles between two flavors of originalism. One is called original intent or original application originalism, which literally tries to figure out what would they have thought the effect of this provision would be in concrete cases. The other, and that was kind of the, if I may say so, the original version of originalism. But it has evolved, and now the consensus view is that, for a variety of reasons we can talk about, that is not the optimal way to approach the question. And instead, a better way is to ask, what is the original understanding of the relevant text? What would people have understood the word fish to mean in 1789 when the Constitution was enacted? And that word's not in the Constitution, but it's an unusually evocative example. It doesn't really matter whether people intended or didn't intend that provision would protect people's ability to hunt whales. What matters is whether the word fish at that time would have been understood by the average intelligent person to include whales or not include whales. Does that make sense?
Yeah.
Mm-hmm. Yeah. No, and the example I love to use is from a case. I can never remember case names. It's like the biggest problem I've got when I start talking about these things. And I always felt bad about this until I walked into my con law class, and Ralph Rossum, who has written one of the better case books for, the Supreme Court PhD level or even undergraduate level cases, he would always grab his forehead and say, what the hell was the name of that case?
Yeah. Yeah.
And he said that he always felt bad about it until he went to a conference with Clarence Thomas. And Clarence Thomas went, what the hell was the name of that case? So, okay, we're all in good company here. But there was a case, and it was there was a law, and it was a drugs law. And it said, if a gun is used in the commission of ... And some smart person who didn't have money but had a gun went and traded a gun for the drugs and got busted for using a gun in the commission of a drug crime. Now, that is clearly not what Congress meant. I think any rational person would say that is not what Congress meant. But Antonin Scalia said, sorry, guys, that's what Congress said. And if they didn't want to say that, they should have said something else. And I'm deeply sympathetic to this, right? Congress writes lousy, opaque laws that require all sorts of interpretation all the time. And then this nonsense happens.
All right, so I had the benefit of being able to look this up while you were talking. It's Smith versus United States, 1993, and it's an O'Connor opinion, believe it or not, not Scalia, but it's...
Didn't Scalia offer this in a separate opinion?
Yes, I'm sorry, you're right. That's right. He filed a dissenting opinion. So that was the division around the court. And you're exactly right. I mean, sometimes you get these cases where the clear text of the law or the constitutional provision points in a direction that just makes no sense. Let me give you an example from Texas, where I'm from. There was a law that was passed that said that in a personal injury case, use or non-use of a seatbelt shall be inadmissible. And this was a law that was pushed by the plaintiff's bar because they didn't want their clients getting dinged for the fact that they weren't wearing a seatbelt when they got badly hurt in a car wreck, right? You wouldn't have had that head injury when you got ejected from the car if you'd have been wearing a seatbelt like you should have been, right? Now, here's where it got tricky. There is a subset of personal injury cases involving seatbelt failures. What if you're a plaintiff's attorney representing a client and you're alleging that the seatbelt failed and they got injured as a result? That law is going to be a big problem for you. Now, obviously, it wasn't designed to rule out those kinds of cases, and probably it's socially optimal if those cases can still be brought. But that law, by its explicit text, clearly is going to prevent those cases from being brought, because you're not going to be able to introduce evidence about whether your client was or was not wearing that allegedly defective seatbelt. That's a tricky, and I believe the Texas Supreme Court split almost exactly evenly on that one. It's a tough call.
It is a really tough call. And you know, you went to law school and I kind of did everything but go to law school, and hard cases make bad law, right? We've heard this over and over and over again, and it's absolutely true.
Yeah, it is. Let's play with this a little bit more, because I think we can really there's more to explore here that I think is going to be useful and interesting. And let me ask you this: how confident are you that when the Second Amendment says that people have a right to keep and bear arms, it is not referring to upper extremities of human bodies?
Yeah. Agreed.
You're pretty confident about that, aren't you?
Yeah.
Well, just like the word jurisdiction in the 14th Amendment has multiple meanings, the word arms has multiple meanings. But I would say all of us look at the Second Amendment and say, well, that's not appendages, that's weapons. What is it that's going on in your head when you make that determination, right? Because in another context, you would immediately see the word arms and be like, oh, that's appendages, right? Keep your arms inside the train. That doesn't mean your pistol. I mean, unless, you're in Baltimore.
Could. Yeah, good.
Right.
But so I think I would say that we, as human beings, we tend to have almost like an unconscious subroutine that's operating at some level that we may only be dimly aware of, if at all, that enables us to make sense of language in situations like that, where we look at that text and we say, okay, there's got the word militia in here, and I understand this thing was ratified 2 years after, well, not 2 years, but several years after we spent 8 years fighting off the world's most powerful imperial government, and we just created a federal government that might theoretically tyrannize us. That's probably referring to weapons, not appendages. But I think it bears pausing for a moment to ask ourselves, why is it that you would laugh somebody out of the room if they said, no, seriously, I think they might have been talking about body parts here. I really do, right? You're doing something there. And I think what you're probably doing is you're doing some combination of contextualism, meaning where did you see the word, in what context, right? Something like originalism. In other words, you had some understanding of the historical context in which this amendment was ratified. That's actually probably historicism, not originalism. And third, you're probably doing some version of originalism where you're thinking to yourself, if somebody said, yeah, I'm good with this amendment, I think this is a good idea, they're saying that not because they think it's important to empower people to keep and carry human body parts with them. They're agreeing to ratify that amendment because they think what it's going to do is protect people's ability to have weapons, right? That, I think, is how we do a lot of constitutional interpretation. There's not one theory that provides a universally satisfactory answer in every single case. And I'll just extend the analogy one more step. I don't think any serious person looks at the Second Amendment and supposes that it protects people's ability to possess, to keep and bear chemical, biological, and nuclear weapons.
No, that's right. But you have to then take a backward step and ask a lot of very difficult questions, right? It says the right to keep and bear arms, and yet we all intuitively know it doesn't mean the kind that could wipe out a state, right? Or a small island or anything like this. So then you're left with, okay, we have a range of arms, starting with the single shot musket all the way to the nuclear weapon.
Yep.
Where is the rational line? And we, for better or for worse, decided machine gun is the line.
Yeah, so let's unpack this a little bit, James. That's a great way to set it up, right? And at the risk of seeming to let me offer a friendly amendment to your setup. Maybe the single shot musket is actually in the midpoint of the relevant spectrum, because what was the original arm for humankind? It was probably either a rock or a pointy stick.
Ant and I have talked about this, and I have an actual theory that I apply to this. I don't know if you'll like it or not. But the right to keep and bear arms was at root a right designed to keep the government frightened of the people, right? Let's be honest. That's what it was, right? The right for the people to defend themselves against who? Not their neighbors, against an intrusive government. So as long as there are enough weapons floating through American society, and right now there are between 300 and 600 million, there are so many that the delta is the lower number. There are 300 to 600 million. And I would say, okay, we have the right to keep and bear arms. It's being satisfied.
Yeah, I think that's right. And can I just say, I try to sort of maintain my facade as a sort of a fairly neutral. Well, I'm not neutral. I'm a libertarian. I'm not going to pretend that I'm not, but I try to not prejudge certain questions or issues, especially when I think it's a close call. But I'm just going to put my cards on the table and say I am so incredibly proud to be a citizen of a country in which the government has to honor and respect the right of citizens to own weaponry with which that government could actually be overthrown.
That's right.
And if you tell me, well, they've got F-16s and tanks and we don't, then you're not really familiar with history, especially modern history, because you don't have to have sufficient weaponry to defeat a government on the battlefield in order to win the war. You have to have enough weaponry to make it too costly for them to continue prosecuting the war.
That's correct. Yep, that's absolutely
and small
correct.
arms are enough for that. Right.
That's I think that's absolutely right. And when you start to look at the more complicated questions, right? I remember my first con law class, and it's bizarre. I was teaching con law in college before I took a con law class in college. So everything is bass-ackwards for me as I learned my way through all of this material. But I learned, I think, pretty early on, and anybody who's ever taught will know that you learn a lot more by teaching something than you ever do by sitting in a classroom and taking a class. I learned early on that my presuppositions, my biases, they were probably not mostly incorrect, but often incorrect. And it came to the point where I would always say, I'm an originalist. Well, la-di-da, right? How does that actually answer this question that an actual court is facing? And it came to me over time that, yes, I have a deeply originalist soul, but what does the text of the damn document say first? And if the text is clear, we're done here. If the text is not clear, we have to go further, maybe much further.
Yeah.
But then I became an original intent person. So if the text breaks down, I divert to original intent. If original intent breaks down, I go to original meaning. If original meaning breaks down, I'm probably at the point of raw logic. And I'm happy enough to admit that sometimes I'm not clear which of these three things I named and the fourth thing that kind of buttresses everything. I'm not clear which one is the appropriate lens to use.
I can help you eliminate one of them, I think.
Please.
I think I can help you eliminate original intent. Because the further we get from the founding, the more often we will be confronted with questions that could never have occurred to anybody at the time that the relevant language was added to the Constitution, like whether it's okay, it's reasonable or unreasonable for the police to use a drone to look inside your bedroom window, or whether a nuclear weapon is or is not an arm within the meaning of the Second Amendment. And if we stick with original intent originalism, we have to do one of three things. We either have to say, if we can't form a reliable belief about what they would have intended as to a situation they could never have anticipated, then the Constitution simply doesn't speak to it. I think that's problematic. Second, we have to project, we can try to project backwards and say, well, if I were able to, inhabit the inanimate body of James Madison and look inside his brain, what would he have thought about drones or nuclear weapons? I don't think that's a seance. That's not constitutional interpretation. Or else what we have to do is say, look, regardless of how they would have intended this language to apply, what is the actual meaning of the word that they enacted as it would have been understood by ordinary people at the time? And I think that is plainly a more reliable and helpful way to answer this question than trying to attribute just to, and the other question, of course, James, is like, whose intent, right? I mean, look at the way laws get passed. Who that? Go ahead.
That's a real question that people never take seriously. And I mean, never take seriously. Now, in the examples you threw out, I would have abandoned original intent in all of them and gone to original meaning, right? Original intent for me is a pretty thin slice.
Okay.
It's, did Madison have some correspondence on this very topic before he wrote this thing? And if he did, and he said, well, here's what it means in a little more detail, I'm going with that every time.
Can I give you an illustration that's going to challenge you?
Yeah, but can you wait for just a minute?
You bet.
And because I look forward to hearing it. But original meaning, whose? Or original intent, whose? The guy who wrote it? The governmental body that said, okay, the Congress? The states who ratified? How far? The individuals in the states who voted in favor? I mean, whose originalism are we looking at here? And I don't really think there's ever a particularly clear answer to that question.
Yep, exactly right. Okay, so here's my challenge. What if it turns out to be the case, and I think we've touched on this before, and if we haven't, we've been in the neighborhood, that everybody in any way associated with the ratification of the 14th Amendment, which, as you know, was ratified in 1868 and includes the Equal Protection Clause. No person shall be denied equal protection of the laws. Every single person in any way associated with the drafting or ratification of that provision, I'm hypothesizing just for the sake of argument, intended that it not apply to women. Would it be permissible today for a court to say, and yet it does apply to women? My answer would be clearly yes, and I have a theory of why that would be. But an original intent originalist would have to say, okay, look, if I'm convinced that literally everyone at the time would have intended that this equal protection clause not apply to women, they would say, okay, then we are still bound by that until the equal protection clause is amended to specify that it includes women. And I think that would be wrong. But if you're going to be consistent with original intent originalism, you're stuck.
Yeah, I want to stress that what I'm about to say is not my opinion. My opinion is that women deserve an equal place at every table, period, end of sentence.
Of course.
However, if I were sitting on the other side of the aisle from you in a court of law, I would say, well, the Supreme Court, the 14th Amendment specifies that the equal protection of the laws is a requirement. It does not specify that the protection of equal laws is a requirement.
I don't find that helpful. It says that no person shall be denied equal protection of the laws. The question is...
Equal protection of the laws. That doesn't mean that the laws themselves must treat everybody equally.
I would challenge that, potentially.
Well, of course you would challenge that. That's the whole point. But this would be my textualist argument against you, that the placement of the word equal actually matters. And if you're going to talk about the equal protection of the laws, that's one thing. And if you're going to talk about the protection of equal laws, that's another. The former allows for women to be treated differently. The latter does not.
I think that's a bit of a, if I may say so, it's a too easy of an out for a very hard question.
Look, I know I'm going to lose that case, Clark, but that's that's an honest textualist argument, and I could back it up with quite a lot to make it more compelling than you might think.
So let me ask you a question. Do you think a 16-year-old is a person?
Of course I do.
Of course. And a 15-year-old?
Of course.
What you say about the fact that the government has the legal authority to compel a 15-year-old to go to school, but not a 16-year-old? Are they being denied equal protection of the laws?
I don't think so. And look, the reason why is a reason that Ant and I talk about maybe once a year when we talk about various ages of consent.
Yep.
These are always going to be arbitrary. Any line you draw that has anything to do with an age of a human being will be arbitrary. And you can pick better or worse ones. Like we seem to have landed on 18 for sexual purposes. Yeah, that's probably good enough, right? We've landed on 16 for driving. Man, I'd like to see that a little older. We've landed on 18 for voting. Oh, I'd like to see that much older. Right? But anything we pick for any reason in the end will be arbitrary. For the want of a line, we will have an arbitrary distinction.
So fair enough. I don't fundamentally disagree with anything you just said, James, although I would like to maybe soften arbitrary a little bit and say instead that there may be a zone of legitimate places to draw the line where it would not be a constitutional violation to be in this part of the zone or some other part of the zone. Let me give you an example. I can't remember if it was it doesn't really matter which chatbot it was, Grok, AI, Claude, to tell me what age do you think that the Second Amendment right to keep and bear arms kicks in? That's actually a really fascinating question.
It's an interesting question.
Yeah. And think about at the time of the founding, you've got kids who are basically
12 or 13.
Yeah.
12
well,
or 13.
You've got kids who are basically raising children by the time they're 5 or 6. If you've got siblings, you're probably being delegated a lot of child raising, authority. You're definitely working on the farm. And in most states, as I understand it, by the age of 16, you're expected to show up for militia service with a gun. Now, fast forward to modern times. Do you really think that 16-year-olds, right, are they on the same level of emotional and social maturity as a 16-year-old from the late 1700s?
No.
Right. So I think there's a zone of reasonableness. The Second Amendment does not specify a particular age at which the Second Amendment kicks in. And I don't think it's unreasonable to say, hey, that's maybe not a number that was fixed in time for all eternity.
But there's still a zone. Something we keep bumping up against is it seems to be losing steam right now, but for a good while, the belief that the prefrontal cortex wasn't fully developed until age 26 seems awfully instructive.
Yeah.
Because that's not arbitrary. Right. And science, broadly construed, seems to be taking a backward step from that right now. How far back, I don't know, right? I don't follow this every day. But the fact that we could get to a third of a human life before we're fully developed says quite a lot. And it's going to have implications in things that I think are very important. And so do you, and so does Ant. I don't know what the right implications are. I just know there will be implications. And I think the best thing you can do when you're looking at constitutional issues is to walk into that door with more or less the attitude I just put out there, that, okay, this is probably going to be complicated. It's going to matter deeply, not only to the person sitting here, but to all the other people who live in this country. There's probably not going to be a cheap, easy, correct answer, or we wouldn't have gotten this far in the first place. And the other side probably has a point.
Can I just go back really quickly? I wanted to sort of pull something together that I think is going to be important in just a second. And that is, I think there's a pretty strong argument to be made that if you did a poll at the time of the ratification of the 14th Amendment, the expectation is that it would not fully apply to women. There were so many laws on the books that really did kind of treat them as second-class citizens. But you know what's pretty interesting? Does that mean a woman could have been convicted and sentenced to death without some semblance of due process? I don't think so.
No.
No.
A cow could be offended. It could be so treated, but not a human being.
And they would have given her a trial, and she would have had the ability to go into court and demand a trial. Why? Because she's a person. And guess what other provision of the 14th Amendment applies to persons, and the 5th Amendment, the Due Process Clause. And so she would be in a really strong position to say, wait a minute, why do I get to have a trial before you execute me? Because you say I committed a crime, but I don't get the full protection of the Equal Protection Clause. Am I not a person under equal protection, but I am under due process? What the hell does that mean? That's a pretty strong intra-textual argument that anybody who intended the Equal Protection Clause not to apply to women was just making a mistake.
Yeah, no, and I think that's a great argument. Yeah, I think that argument is probably irresistible no matter what political persuasion you are. If you looked at it honestly, you would have to look at that and say, yeah, of course.
Well, and you know where original intent, originalism comes up short also is, imagine we finally encounter intelligent life in the universe. Are they persons? Does it matter whether they have some amount of human DNA in them, or does it just matter whether they have the ability to manifest some of the same things that we attribute to humans, like the ability to take responsibility, right? Okay, so you know where I'm going with this. And you know what? We might get there sooner on AI than any of us are comfortable with. So it might not be an alien intelligence. All right,
not just AI. Just recently, I ran across an article. Some South American country, I want to say Brazil, but don't quote me on that, was passing legislation or considering legislation giving protection to certain animals. Now there are crazy people who want to give protection to goldfish, but for example, octopus, dolphins,
the puppies of the sea,
these are clearly intelligent entities.
Yep.
Yeah, octopuses are way more intelligent than dogs. They are surprisingly intelligent. But
if you've never seen the movie My Octopus Teacher, watch that documentary. You'll never eat another octopus, and you shouldn't.
Yep. That's right. Yep. That is an unbelievable movie. I enjoyed every second of it, and I'm a movie connoisseur. This is a great movie. So thanks for throwing that out there. Look, as an originalist, right, as an original intent guy, I would say on the alien question, there's clearly no answer here.
Right.
Right. As a textualist, I would say there's no answer here. So that brings me in my, checklist all the way down to original meaning. And I think there's an answer there. And then if I want to dip below that into raw logic, I know there's an answer there. But even the history of philosophy doesn't provide much of an answer. Everybody from Plato to Nietzsche, the only one who addresses the possibility of non-human intelligence is Immanuel Kant.
So, James, I want to take one more stab at convincing you to just drop original intent, originalism, either altogether or drop it way down the list. Because, imagine that the Equal Protection Clause was added to the Constitution in 1868 as it was, but every single person who voted to do that had their fingers crossed behind their back and in their mind said, yeah, but obviously not black people. Right. So their intent was, nope, this will not apply to black people. We know they're inferior. We know that would create like social upheaval and havoc. And I will tell you, there were definitely people who had their fingers crossed behind their back at the time in that manner. I don't think that matters a bit. I don't think it matters whether only 10% of people had their fingers crossed behind their back or 100% of people had their fingers crossed behind their back. The language that they voted to ratify said no person shall be denied equal protection of the law. I don't care what they intended.
But as a textualist, I agree.
Okay.
I don't have to get to originalism. I don't have to get to original intent.
Well, you sure do when we encounter alien life, James, because they couldn't have imagined what persons meant back then.
I think that's probably right. Although I'll admit I haven't thought it through.
Okay.
I'll have to go think it through. But my knee-jerk reaction is that there's no way you're not right here. But I really, there's no way you're not right.
Can that just be the subtitle of this episode, by the way?
Sure. There's no way you're not right. There's no way Clark's not right. I promise you, Clark, if we can fit that on the thumbnail, that could be the title of the episode. Let me remember. I have already forgotten. I promise you, Clark is right. Was that something of that nature?
It's
Ant
recorded.
will
You can go back and look.
Ant will extract the relevant text from the.
That's right.
From the exchange.
That's
Hey,
it.
can I just
let me
really
throw
quickly-
in?
Yeah, go ahead.
Yeah, please. No, go ahead because I'm off topic.
Let's go back to the Second Amendment really quick, because I think this might give us the opportunity to encounter this question of originalism in one of its most difficult applications. To my knowledge, and I looked, believe me, there was no law at the time of the founding that restricted anybody's ability to own the most lethal weapons available at the time. And that was field artillery. That was cannons. There was nothing more lethal than a cannon in the late 1700s, except maybe a giant stack of gunpowder. And you know what? Private individuals could own both. Now, there were laws about where you stored it and how you could use it, etc. But in terms of just keeping it, just having it, no restriction at all. What the hell does that tell us about whether somebody can own a machine gun, a Stinger missile, or even a tactical nuke today? Man, that's a tough one. Now, I don't think that entails that necessarily the Second Amendment protects the right to own all of those things, but boy, do we have some work to do to come to a principled answer to that very challenging question.
Yeah, and I think the only principled answer, the only one I've been able to come up with, is a balance of power answer between the people and the government. It's it. I don't think there's a better answer out there. I think if the people are allowed their Second Amendment rights, that by definition frightens the government into not messing with the people as much as it would otherwise.
Well, James, I'll tell you, when you said the word balance, you just ruined at least 4 sets of underwear on the U.S. Supreme Court.
Oh, look, I understand, and I would never use the word balance before a Supreme Court. Right? This is a dreadful mistake. If there's ever a balancing test, you've already lost as a human being.
But you know what? I think you're right.
You take my point. Take my point.
Of course, and you said it all.
Not a bad point.
It's a great point. You already basically said it earlier, which is that there is a reason why it is irrational and nonsensical to suppose that the Constitution protects the right of an individual to own a weapon that could eliminate the entire island of Manhattan with the push of a button. It takes some work to get there, which is, by the way, going to mean that a substantial number of people are not going to accompany us on this journey. But I believe you can get there in a principled way. But you have to really drill down, think hard, and be consistent. So
I think that's right.
And you know what? I don't want to engage in overt flattery here, but there are very few podcasts I appear on whose listenership would have a better chance of completing that journey than Words and Numbers listeners. But there's a reason why in your mind you really I think almost anybody gets that not only do we not want, but the ratifiers of the Second Amendment would never have embraced the vision of a world in which private individuals have the ability to own unlimited amounts of lethal chemical and biological and nuclear weapons that could potentially wipe out all of humanity. And you get to go into court and say, you can't take that away from me. I have a Second Amendment right.
Further. Yeah. I think we can go even further and say they would have not thought that you could own weapons that could indiscriminately destroy every house in your neighborhood. Right? I don't think you have to get to the nuking of Manhattan. You might have been able to legally own a cannon, but trust me, you couldn't turn it on your neighbor's house.
Do you want me to give you an Easter egg?
Please.
You know what's doing the important work here? It's not the word arms, it's the words right and infringe. The Second Amendment says that the right to keep and bear arms shall not be infringed. But the First Amendment says the right of free speech shall not be infringed. But that doesn't give you the ability to go and defame people without consequence. It doesn't give somebody the ability to disclose all of our national secrets that they've been exposed to by virtue of their employment in an intelligence agency. Infringe is a value-laden term. It is not an objective term.
That's right. And in the First Amendment, you can't practice a religion that allows or requires polygamy, for example, to go to our Mormon friends, or human sacrifice to go to the other easy example, right? But when we talk about infringement in Second Amendment terms, if I have to go get a license from a government official to allow me to carry a sidearm in public, my right has been infringed.
Well, that's a really interesting assertion, because I would take the position that the ability to travel is also a fundamental right, albeit unenumerated, just like my right to get married, have children, and guide the upbringing of my children. But they do require us to get a license before we can drive a car. Is that
Yeah,
an
and
infringement of your right to travel?
I've often said so only for the purpose of being consistent. I've long said that the fact that I can afford a car is my license to drive.
You know what? It just occurred to me. Have either of you seen the wonderful Steve Martin movie Parenthood?
Yes.
There was an amazing scene where, of all people, Keanu Reeves, who has a minor part but a great part in that movie, is speaking to the mother of his girlfriend, and he's alluding to the fact that he was clearly abused by his single father as a child. And he says to her, you know, they'll let any butt-blanking a-hole be a father, but they make you get a license to drive a car.
Right.
You know, there's something to that, right? I mean,
There is.
We are not always consistent, I think, in our orientation to what the prerogatives of government are before they can prevent you from doing a thing. Take, for example, the difference between requiring some level of demonstrated aptitude and perhaps even a license before you perform surgery on another human being, on the one hand, versus requiring somebody to have a government-issued occupational license before they can sell a floral arrangement that they have created, an actual case that I litigated, as you guys remember. Somewhere in between, there is sanity, but it's not at either end of that spectrum.
It is absolutely not at either end of that spectrum. And just to make a little bit of a finer political point to everything you just said, I think there are a number of rights, marriage among them, right, that are just simply pre-political.
Yep.
They existed long before the state. They will exist long after all the states of the earth right now disappear. And government has no business sticking its nose in it. I mean, just none. And I think the right to self-defense, I'm with Hobbes on this one. This is the ultimate pre-political right. If you don't have the right to self-defense, you don't have the right to much of anything else either.
You know, it's such a great point, James. And this really, to me, is one of the most powerful arguments against people who do not believe the Constitution protects what we call unenumerated rights. That means rights not specifically listed in the text of the Constitution. And think about it this way. Imagine that you are being tried for either aggravated assault or even homicide because you resisted an attacker. And you resisted them successfully to the point where they were badly injured or even killed. And there's no dispute that they initiated the aggression and that your life was in danger and that the police were not going to get there in time to save it. So what did you do? You helped yourself. You reacted with force, and you hurt the person or you killed them. Every single state in the country will allow you to make a self-defense argument in defense of those charges. And any state that tried to prevent you from making a self-defense argument, the court would say, that is a violation of due process. This person has a right to argue self-defense, and it is not articulated in any constitution that I'm aware of that you actually have that right, but we all know it on some almost fundamentally genetic DNA level, don't we?
It's probably the very first right you have, right? It is the right to life, differently understood, right? Do you have the right to exist? Yes, that absolutely implies that you have the right to defend that life against any aggressor, including the government, right?
Well, yes.
Hobbes said if you are tried and convicted, justly so, and they're going to put you to death, you have every right to try to get away from them and do what you can.
You know, one of the most interesting areas to explore the difference between thoughtful and not thoughtful people is in an area where you don't immediately think about whether the right would apply here or not. You have to start from scratch. And I had a fascinating conversation with a reporter some years ago who wanted to have a conversation about whether you have a constitutional right to defend yourself with lethal force against an attack by a wild animal.
Of course you do.
And this is so fascinating, James, because I'm with you, but there have been a number of cases in which trial court judges have said, no, because it's not written down anywhere. So, and this comes up sometimes when people will they'll shoot a bear out of season, or they'll shoot an endangered species or something, and they'll get prosecuted for it. And the only defense, because they did shoot the animal, is necessity. Is I was in fear for my safety or the safety of my children or whatever. And there have been a number of people who've been convicted of shooting a bear out of season or an endangered animal, and it has to go up to the Court of Appeals. Every time this has gone up on appeal that I'm aware of, the court has concluded exactly with you, James, which is correct. Like, yeah, of course you have a right to shoot a human being who's attacking you. Clearly, you have a right to shoot a mountain lion. Come on, right?
This is so idiotic. I can't believe we're even talking about it.
And yet there have been judges that have said no somewhat robotically, because why? Well, it's not written down anymore. So what do you want me to do? Right. And unfortunately, we see this in other settings where maybe it is not so laughably obvious, the mistake that they're making. Right. But we see, I'll give you an example. There are many judges, or not many, it still hasn't come up a whole lot, but there are some judges who have said, look, the fact that airlines routinely fly airplanes over your head at 30,000 feet means that and that's not an unreasonable search, means that it's also not an unreasonable search when police go rent a Cessna and fly it at 1,500 feet over your property because they think you've got some marijuana plants, right? So that's what the Supreme Court said. And then when it came up with helicopters at 500 feet, they're like, well, they're still flying and they're still up there, right? And then now we're in the age of drones, where it's like, yeah, they can fly a drone right up over your house and look at everything. And I think the difference between a thoughtful judge and an unthoughtful judge, or one difference, is a judge who can say, look, there's a big difference between an airliner flying at 30,000 feet on its routine route, not chartered by law enforcement for the specific purpose of looking down into your backyard, and a friggin' drone that's 18 feet above whatever it is you're growing in the backyard, with a camera that can resolve to the level of whatever it is that is parasiting the plants that you're growing, right?
Clark, I'm so crazy as to believe there's a difference between a commercial flight at 30,000 feet and the police at 30,000 feet.
Right.
We don't have to get the drones. 30,000 feet is bad enough.
I'm with you, and that's one reason you and I will never be on the Supreme Court, James.
Well, there's lots and lots of other reasons.
Yes, there are.
For me.
Let me, as we run up on the hour here, let me throw out an observation that I made. I was thinking about this episode. I've been looking forward to it for some time. I was in St. Augustine last week, and was in a basilica there. A basilica is a major church, and on the wall was a placard with the edict from Pope Paul VI declaring this building a minor basilica. And I thought about this episode, and it comes back to Clark's point about there is no perfect approach to this. You use a variety of approaches depending on the circumstances. And I'm looking at this proclamation, and it's written in Latin. Now think about the Catholic Church for a moment, not in terms of the religion, but in terms of the legal system. And it's not, there is still a legal system within the Catholic Church. In fact, our friend James Stacey Taylor's wife is a canon lawyer. She's a lawyer within the Catholic Church. But going back several centuries, there were, at least in England, parallel legal systems that you could be tried. You could choose to be tried under the court system of the crown or the court system of the church. And so there's a whole legal infrastructure there that has nothing, it's completely separate from the
If I can interject a quick point right here, this is why the phrase "without benefit of clergy" is actually important in legal things. It doesn't mean you don't get to consult a priest. It means you don't get to have your trial in that system.
Held in the church, the ecclesiastical court, right? But here's what struck me as I'm looking at this placard and thinking about this upcoming episode. The placard's written in Latin, and what does everybody know about Latin? It's a dead language. It doesn't suffer from one of these problems we've been talking about, which is the meaning of the word changes. Fish in Latin means something and has always meant something and will always mean something. So to that extent, the ecclesiastical legal system gets around at least part of the problems that we've been discussing.
Yeah, part of it, but there's no Latin term for internet either, and that you can see where,
Right,
because
there are
because it doesn't develop, it's both a blessing and a curse.
Yeah.
And I want to just really quickly, if I could, I wanted to address your point, which is that there's a whole range of specificity in our Constitution, right? And so just to take one example at one end of the spectrum, you have to be 35 years old to be president, right? Do you think that's going to be really challenging to apply if we start colonizing other planets and you've got somebody, from Venus who's like, hey, man, I'm 35 Venus years old. That might be 21 in US years, but I'm still eligible, or, bang it out to Mars and whatever. I don't think that's going to be particularly challenging, right? On the other hand, arguably, one of the most important passages in the entire US Constitution might well be the 14th Amendment's provision that no state shall make or infringe any law that shall abridge the privileges or immunities of citizens of the United States. And I'll tell you what, I defy you to tell me what you think those are without doing a little bit of research, because it doesn't jump out the page at you the way years does. Those are Earth years, and they're always going to be Earth years, right? But imagine they led with that provision, by the way. It's the next thing you encounter after the citizenship clause in the 14th Amendment. Probably was fairly important. And guess what? The U.S. Supreme Court, just 5 years after the 14th Amendment was ratified in 1868, read the Privileges or Immunities Clause right out of the 14th Amendment and hasn't revisited it since. To hell with that.
Yeah, but when gay marriage started to become a thing and the Supreme Court gave its blessing, I think it was to avoid getting back into privileges and immunities. So privileges and immunities kind of carried the day without ever being mentioned as such.
Well, that's provocative, James. I don't know if you want me to respond in this podcast or put that as a post-it for the next one, but I disagree with you a little bit.
Yeah, no, next one.
Oh,
next
all
one,
right.
please.
Oh man, no, you can't do that. I want to hear the disagreement.
We can, because the disagreement is honest, sincere, and time-consuming.
All right, so let's put a pin in it, and we'll say that you and I will come back to Obergefell, which is the case that you're talking about, and we have yet to square off on Brown v. Board of Education, which has been...
That's right, I'm coming for you, motherfucker. I'm coming for you.
I know you are, and I'll have steel for you.
That's right. Immovable force, irresistible object. Yes.
All right.
People have spoken. They want this. So let's leave it on that happy note.
Thank you. Thank you for doing this.
This has been great, and I really do appreciate it. And I think in the end, I thought you and I were probably going to disagree a lot more than we really did. I think we've got a second level minor disagreement about the location of one category over another that you thought for me was massive and that to me is actually minimal. So it probably in the end doesn't amount to much.
Yeah, I'm with you. And if I could, I'll just make a substantive point at the end that I think is really important, which is that I think we should not be overly surprised when decent, thoughtful people converge on the same answer through different routes or different means. That's probably not accidental, right? Because what it suggests is that for many questions, there is actually a demonstrably better answer than all of the other alternatives. And it's not necessary. I don't think it's terribly surprising if decent people who are thoughtful get there by different paths. That wouldn't surprise me at all.
Yeah, no, nor I. And if anybody out there has any doubt about what Clark just said, ask yourself then, how is it that almost every, if not every, human society ended up with some version of the golden rule as the unofficial rule to govern all things?
Yeah, no, I'll throw something out. I don't want to be patronizing, Amp, but I'll say something that you might find gratifying because, as much as you and I love and respect each other, we have fundamentally different worldviews because yours is a fundamentally religious view and mine is not. But as you know, I'm incredibly passionate about criminal justice and getting that right. And your listeners know that too, if they've heard me on your show. There is a partner at a large law firm named Matthew Martins who wrote a book about American criminal justice from the perspective of the Christian Gospels. And it is eerie how his assessment nearly perfectly overlaps with mine. And we come at that question from totally different perspectives and arrive at nearly identical, not only conclusions, but also perspectives, observations about the system. We see it in the same way and we come to the same conclusions about the way that it should be. We get there from totally different value systems, but we converge on essentially the same answers. And I find that incredibly moving.
And that's, I often tell the story. You and I met in this context. We were both giving lectures for an organization, and it was my first experience with them. And it was a free market thing, and I'm giving arguments about free markets and why they're good and so forth, and the implications, all from the perspective of an economist. And then I hear a friend of ours giving the same arguments, but from a basis of philosophy. And it was the same phenomenon. This light goes off in my head that I must have hit something that's actually very fundamentally true for me and this other guy to be coming to the same conclusions using completely different tools.
Yeah, it's like we've all perceived the same elephant using different senses and come to the conclusion that the thing we are in the presence of is in fact an elephant.
Yeah, yeah.
Kind of comforting when you realize that you're not alone.
Yes. On that note.
On that note, yeah, that's probably right. There could be no happier thing, at least no happier thing that I could say. Maybe other people, but not me.
Thank you
So,
again, Clark.
Of course.
Hey, my
Clark is
prediction came true. Favorite episode ever. I've really enjoyed this. Thank you guys for having me on.
Yeah, this was fun. I suspect the Brown v. Board is going to be even better.
I'll
So
hold you
we'll-
both to it. I
Yeah, we'll
thoroughly
do that
enjoyed
one.
listening to this episode.
I enjoyed speaking in this episode. Clark, it's always great to see you. Ant, nice seeing you again. And I'll see you both some other fine day.